Well, to me, Sir Robin, no, it would really help unclog the dockets of our courts, because we have to remember the purpose of preliminary investigations is twofold po. No? Firstly, it's supposed to make sure that individuals, respondents being accused of committing an offense is not unduly burdened into going into trial if there is really no evidence against him or her. No? And secondly, to save the state from the expenses and all the manpower that it has to put into prosecuting cases if later on it will just prove that there was no evidence against the accused. And so this move, to me po, will help unclog the dockets of our courts, which are really, at this point in time, very much clogged na po.
Yung in terms of unclogging the dockets, I think that's pretty clear. But are we unclogging it with many potential unintended consequences? Primarily being that a lot of people who may warrant to be held can easily now get past the preliminary investigation stage. And does this not address the problem on the wrong side? Some people might argue that, therefore, to increase the certainty of conviction, then we just have to pour more resources and build more capacity in our Department of Justice.
I think it works that way po, Sir Robin. No? Before they file the case, then they have to really exhaust all effort and to make sure that they have turned all stones and look for all the evidence that are out there and to see if there is really enough evidence to engender a belief that a crime was committed and that the respondent is probably guilty of committing that crime. So the result is only that they should not unduly file cases and further clog the dockets of our court if they are not certain, no? As put by the circular, that they have not reached that so-called reasonable certainty of conviction before they file a case. And so you're correct po. It should also call for more support to our law enforcement, the investigating arms of our prosecution service and to our Office of the National Prosecution Service so that they can really gather evidence and exhaust all efforts before they really file cases in courts.
Okay, this change from probable cause to certainty of conviction, can you take us through that? What exactly would need to be met for you to file a case?
Well, this degree of, we call it as quantum of evidence. Previously po, Ma'am Gretchen, no? The quantum of evidence in this preliminary investigation is what we call as probable cause, or with something which in a reasonable mind, or that the mind of the prosecutor, there is enough evidence that would engender that belief that there is a crime that was committed and that the respondent is probably guilty. But this time, the circular calls for a higher quantum of evidence on the part of the prosecutor who is resolving this preliminary investigation. And so it should not be just mere probable cause. No? Probable cause is something that we could say it's higher than a mere suspicion, but it does not need to be beyond reasonable doubt, or there has to be moral certainty. If we say probably reasonable certainty of conviction, then it is something that is just below the quantum of evidence in convicting an accused, which is proof beyond reasonable doubt. So in this case, before they file a case, although they do not have sufficient evidence yet to say that there is proof beyond reasonable doubt, but that they should have at least a reasonable certainty of arriving at a conviction in the evidence that they have and will be presenting in court, and not just mere probable or probability of getting a conviction.
At attorney, to that point lang po, last question na lang po. Sabi nga po ni Justice Secretary Remulla, they are in constant consultation with the Supreme Court on this. That consultation notwithstanding, and we imagine that's very important, but notwithstanding the consultation, does the court actually have any say in this, or is this completely a prerogative under the Department of Justice?
With regards to the determination of probable cause, or what they call now reasonable certainty of
Just to clarify, sir,
conviction,
not on the determination, but just on on that decision that this is now the standard.
Yes, po, because this is to me, I believe it is an exclusive, an executive decision. No? What evidence or degree of evidence they would want to have before they file a case, because that is the discretion that is afforded to our prosecutors in determining the sufficiency of evidence that they feel engenders the probability that the respondent committed the crime being accused of.